So I'm hopeful that the Supreme Court will make a ruling that will recognize that the safety of our families is more important than people's desire to be able to shoot guns that really are weapons of war.
It's Governor J.B. Pritzker being asked about the U.S. Supreme Court ordering the states to file a response to the Naperville challenge to that city and state gun ban. That's not the only case in front of the U.S. Supreme Court. We've got more filings from Dan Calkins in their case challenging the Illinois Supreme Court's questions of conflict of interests and the lack of recusal of a couple of Supreme Court justice candidates. Bishop on air with you. Be sure to like, subscribe, hit that notification bell, and follow along as we keep you updated on the latest litigation against Illinois' gun and magazine ban. Let's go ahead and get into it with the latest coming out of the U.S. Supreme Court. Again, you've got the case that Dan Calkins has brought forward, and that was docketed mid-November, and the governor's office was to respond by December 14th, and instead of waiting until then, they went ahead and filed a response in pretty short order on Friday, issuing that response. Let's pull that docket up so you could see this for yourself. So they had the filing on November 9th. It was docketed on November 14th, and then you have the governor's office waiving a response from their side. Just ultimately saying that they do not intend to respond. But when we talked with Jerry Stocks yesterday and shared that with you, and he had delved deep into the reasons he is bringing this to the U.S. Supreme Court, the Caperton v. Massey challenge about conflicts of interest with state Supreme Court justices getting funds from people who are defending themselves in front of the Supreme Court of a particular state. Well, that's the question here in Illinois when it comes to two Supreme Court justice candidates. Now, when we talked with Stocks, he said that he was going to file a supplemental brief, and indeed that supplemental brief being filed, and you can pull that up on the docket and see for yourself, and we'll go through this with the main document here. And you can see that it really kind of breaks down some of the things that Stocks talked about, supplement to the case, and highlighting a variety of things. Newly discovered material, they say, discloses $7,300,000 additional to the $2.6 million direct financial contributions to the original petition, indirect campaign expenditures supporting the candidates of Justice Rochford and O'Brien by a political committee backed by defendant Illinois Senate President Don Harmon. The sole officer of the political committee, All for Justice, is Luke Casson, and counsel of record defending Harmon in the proceedings below the case. The expenditures from the benefit the Justice Rochford and O'Brien were concealed from public until several months after the election. On November 21st, Hall for Justice was fined $99,500 for violating campaign disclosure laws with the delayed public disclosure of the expenditure supporting Justice Rochford and O'Brien. Funds controlled by defendant Harmon contributed $700,000 to All for Justice. Goes on to say that neither Justice Rochford nor Justice O'Brien disclosed or otherwise acknowledged All for Justice expenditures supporting their campaigns of origin. Goes on to talk about the reasons for granting writ, and that's why they, of course, filed this, and all of the other funds that were involved, including Justice Rochford and O'Brien receiving an aggregate sum exceeding $2.5 million in direct contributions from defendants, and received $7.3 million in indirect campaign expenditures benefiting their respective campaigns. The combined expenditures to benefit Justice Benjamin in the Caperton challenge exceeded the total amount spent by all other supporters of Justice Benjamin, and was 3 times more than was spent on Justice Benjamin's own committee. In the present case, the combined expenditures originating with or controlled by defendants on their counsel to benefit Rochford and O'Brien was $10 million, totaling 55% to 60% of all expenditures to support their campaigns. So you can see here that the filing that was just made to the U.S. Supreme Court highlighting how it's a lot more than the Capitan challenge. So we were told by Stocks that would happen, and they filed that. But you also have a few other documents that were filed, and also kind of highlighting some of the news reports that have been made about the All for Justice campaign fund. So we'll go to some of the latest in that U.S. Supreme Court filing from Dan Calkins' case, raising question about the conflicts of interest. And in particular, you've got here a Chicago Tribune article from November 21st. Democratic PAC shifts cash out of its account as it gets hit with one of the biggest state election board fines ever. It goes into detail about the $99,500 in fines All for Justice had to pay because of the $7.3 million in independent expenditures supporting Democrats Elizabeth Rochford and Mary O'Brien. So that has been filed to the U.S. Supreme Court after the governor's office on Friday did not provide a response other than to say that they weren't going to respond. And you can see that document, of course, by going to the U.S. Supreme Court's docket entry. And you see, I do not intend to file a response, the governor's office said. So the governor facing this, not just with the challenge that Dan Calkins has, but you also have the challenge that Robert Beavis has brought forward, and that's what the governor has to respond to by Wednesday. So the National Association for Gun Rights, they have this case for Robert Beavis, and they're supposed to have a response from the governor by Wednesday, December 6th. So we'll be watching like a hawk for that filing if it does indeed come in before December 6th at 5 p.m. Eastern time, which would be, what is that, 4 p.m. our time? So we'll be able to see that document. Hopefully it gets filed. But Governor J.B. Pritzker was asked Monday at a stop in Springfield. Didn't realize he was going to be taking questions, but he was, and indeed he was asked about, this being in front of the U.S. Supreme Court. Now he has to file something by Wednesday. And if he is concerned, the questioner asked about the conservative U.S. Supreme Court possibly slapping down Illinois' ban on semi-automatic firearms.
Well, I'm always concerned about what I think is a very, very conservative U.S. Supreme Court making decisions that are not good for a majority of people in Illinois. Having said that, I do also think that the case that will be brought to them is one that is a rational one for them to decide in favor of a ban on assault weapons. There has to be a limit to the kinds of weapons that people can keep in their homes, and we have lots that are available to people, lots of weapons to protect yourself, and those that are available for sporting use. But guns that shoot 30, 50, 100 bullets at a time are guns that people don't need to have in their homes for protection or for sporting use. And so I'm hopeful that the Supreme Court will make a ruling that will recognize that the safety of our families is more important than people's desire to be able to shoot guns that really are weapons of war.
So the governor was then asked about the possibility of a preliminary injunction being issued that could halt the law in its place.
Well, sure. Any time that more weapons are being purchased that are weapons of war that can shoot the kinds of rapid fire mechanism that can shoot rapid fire is dangerous for people. So. But I don't think that that's what will happen here. I know that I guess Coney Barrett is being petitioned for that. So we'll have to see. But I think in the long run that we will win at the Supreme Court. But are we concerned? Always a little bit, because you never know what the outcome will be.
So you never know what the outcome is going to be, the governor says, as we await for his filing to the U.S. Supreme Court to respond to the Beavis application for writ and to possibly have this case go in front of the U.S. Supreme Court. But what they have to respond to is the request for a preliminary injunction while this case continues. And this would come from the U.S. Supreme Court, not from the Southern District of Illinois, not from the appeals court, but from the U.S. Supreme Court. So we'll be watching that closely. Some other things happening.
I have a lot of solutions.
Of course, you've got,
one of them,
we'll get to that in a moment. Some other things going on, of course, in the courts and the litigation against Illinois' gun and magazine ban. We're still watching the Southern District case where December 12th, that'll be heard from the federal firearms licensees of Illinois. Friday, the state responded in that with a motion to dismiss, saying that the federal firearms licensees of Illinois don't have a case, essentially. So we'll try to connect with somebody from the plaintiffs on that end to kind of get their response, at least here in the media, as to the governor's office saying that that should be dismissed in the Southern District. So while that's playing out, still no movement in the MAG case on vagueness that's in the Southern District as well. Didn't see any updates on the Seventh Circuit Court of Appeals with all the different plaintiffs asking for the entire Seventh Circuit Court of Appeals to review. So all of those things we're still watching here. With Bishop on air. One thing, though, I do want to just briefly touch on is the Joint Committee on Administrative Rules and second notice of the gun ban registry rules. I've been trying to get the latest here, and we'll see if we can do this in real time. If you go to the Joint Committee on Administrative Rules website, just search JCAR Illinois, and you'll be able to find it. Their agenda is posted for their December 12th meeting, and the December 12th meeting does include emergency rules from Illinois State Police. I'm told that the second notice has been kind of pushed through, but we have yet to see that. Let me see if I can pull this up with the latest Illinois Register. This again is that rolling document that shows all of the different administrative rules, and you can go through and read all of the Illinois State Police changes that they're making by emergency rule to the FOID Card Act to require registration of certain semi-automatic firearms. And it goes through and lists a whole bunch of things. We are going to have to delve deeper into this, but I'll tell you, I've been sitting here most of the day trying to get to the latest and to see if indeed the second postings have been made. And if you go to the Joint Committee on Administrative Rules, you can actually pull up the second notices. And if you click on second notices, I don't see yet where it's been posted. So I've been refreshing this page as well and have yet to pull up the latest. So we'll be watching that as well, something that a lot of people are interested in. I do have indication that some of the changes that are being made include defining what a shooting range is. That was one thing that was kind of up in the air. What exactly is a shooting range? It also talks about some of the changes on transferring firearms and some other different types of definitions that are going to be included. So we'll be watching that closely. December 12th is going to be a big day, not just in the Southern District of Illinois, but also with the Joint Committee on Administrative Rules. So those are just some of the latest here. Of course, filings happening in various courts and jurisdictions, but we'll be tracking it for you all throughout. Greatly appreciate you guys checking out the program as you do, so you can stay up to date of what's going on. Of course, you can find me anywhere. Just search Bishop on Air and make it happen so that we can connect, and you can email me as well anytime. Just search Bishop on Air and find the contact info. Email me bishoponair@gmail.com, and stay tuned. We got much more coming up. All right. You know, there was another case that was in front of the Illinois Supreme Court that Governor J.B. Pritzker was a chief defendant in, and that was the case challenging the Safety Act's pretrial fairness provision that ended cash bail. Well, justices weren't asked to recuse themselves in that case, but regardless, they did proceed forward despite those questionable campaign contributions from Democratic leaders. So ultimately what happened there was the Supreme Court sided with the state and said that no cash bail would go into effect September 18th. And some of the things that, of course, were brought up were, is it really going to make the communities safer? And that's something I think is still up in the air. I connected with the McHenry County State's Attorney, Patrick Keneally, and asked him about the Pretrial Fairness Act and how they are proceeding forward with it.
The joke. I mean, we haven't looked at the numbers, but the type of people who are being released with much of their criminal histories, especially on non-detainable offenses, it is the decisions that the legislature has foisted upon us at the 22nd Judicial Circuit is totally out of step with the expectations that citizens in McHenry County have for their criminal justice system and what's necessary in order to keep McHenry County safe. So
Patrick Keneally saying that it's a joke, but of course it is the law of the land. When we also chatted with the Kankakee County Sheriff, he laid out, some of his concerns and also what he'd like to see happen. So here is the Kankakee County Sheriff, Mike Downey, talking about the problems that he's seen so far with the Pretrial Fairness Act ending cash bail in the state of Illinois.
A lot of failures to appear, and we anticipated that. I mean, as I told our Criminal Justice Committee a couple weeks ago, the Safety Act is playing out just about how we figured it would play out. It is, the things that were going to happen, we predicted were happening, are happening. People aren't showing up for court. There's nothing that is enticing them to show up to court. We have a significantly increased number of individuals who get stopped for a traffic offense, or we attempt to stop them for a traffic offense, and they flee and elude us. And across the state, I know every jurisdiction probably has different pursuit policies, but I can tell you that almost every jurisdiction will not pursue an individual fleeing from a from a stop for speeding. And so, because there are no ramifications, and that's frustrating for law enforcement. It not only endangers the police who are doing their job, but it also puts our community at risk for people driving away, fleeing at a fast rate of speed.
Again, Mike Downey with the Kankakee County Sheriff's Office talks about the importance of addressing some of the problems, and those problems, of course, going to come from the application of the law, but who's going to be lobbying? He talked about how indeed they are expected to hit the streets in Springfield while lawmakers are there to discuss the next steps and what possible changes there could be for this law ending cash bail in the state of Illinois.
I think there are some lobbying efforts going on right now. Whether or not anything gets put down on paper and whether or not Don Harmon or Chris Welch call them up, that's certainly on them. But we have a significant number of issues that we want to deal with. And, we're just hoping that there's enough time that has gone by since not only the Safety Act, but the Pretrial Fairness Act has been in effect since September 18th, that somebody looks at these and says, you know what, we can do some things to change, to make things better. And we're not looking at this to make things better for the sheriffs. We're not making things better to look for the police, although that's certainly something that we care about. We're looking to make things better for the communities that are being overrun with criminal activity.
Well, then I asked if he had some kind of magic wand. What would he do to the law if he could change anything?
Yes, if I had a magic wand, Greg, I would get rid of the non-detainable offenses and give the discretion back to the judges, which was what part of the original lawsuit was that Jim Rowe filed, our state's attorney. The judges right now for certain offenses have no discretion whatsoever in determining whether or not somebody should be detained. So if somebody commits 10 retail thefts in, a 2-week period, there is nothing in that legislation that allows a judge to hold them unless two things, unless they are a threat to the community, or a threat to themselves, or if they are a flight risk, which there is nothing in the threat to a flight risk. There is nothing that we are allowed to show that makes them a threat to flee, other than if we catch them with a disguise and an airplane ticket to some other jurisdiction. And the likelihood of that is, as we've indicated a number of times, is none. You're never going to prove that somebody's a flight risk. So, and not showing up to court, those failure to appears is not part of being a flight risk. That's not considered being a flight risk. So, the discretion needs to go back to the judges. They can look at a number of things as to how they affect the communities, because what we're seeing happening is we're seeing a number of retail thefts, and I'm sure you've seen all the smash and grabs, and you walk into a store and people are walking out with armfuls of retail items. And, until a judge can say, we're going to hold you in jail, and hey, forget about cash bail. I mean, we know that that's probably not coming back anytime soon, but just give our judicial system an opportunity to say, you need to be in jail, not necessarily because you're a threat to our community or yourself, but because you are a criminal nuisance and you need to be off the street. Because who's going to bear the cost of all these businesses who are losing money from people stealing from them? Guys like you and I are, the taxpayers of the state of Illinois are. And so that would be my number one thing with the Safety Act, is to give the judges discretion and eliminate these so-called non-detainable offenses. But on the other hand, you still have to understand that the judges have to take into account, if an individual steals something for the first time in his or her life, I understand not holding them in jail for any period of time. Okay, we all make mistakes. But then if that continues, and you continue to steal, you continue to go in and commit retail thefts, at some point you have to say, look, we have to put you in jail so that you don't go and cause problems in these retail places.
So again, that's Sheriff Mike Downey and the state's attorney from McHenry County, Patrick McNeely, talking about the Safety Act, the Pretrial Fairness Act, and some of the problems they've seen with that. Not the last we hear on those issues. I imagine there'll be plenty of debate whenever lawmakers return to the state capitol in mid-January. Guys, that's a brief update for you. A little bit shorter of a show than I typically do, but greatly appreciate you guys tuning in. As always, we'll be on top of it, all right? Waiting for the December 6th filing from the governor to the U.S. Supreme Court. Waiting for the December 12th JCAR hearing. Waiting for the December 12th Southern District of Illinois hearing. So a lot of things are going to be popping off, and I hope that you like, subscribe, and hit that notification bell, all right? We'll see you here soon. It's Bishop on Air.